Welcome to John Redmann, Power of Attorney. I'm Attorney John Redmann, and like all of you, I have a million questions and concerns about what's going on in this unprecedented time of the coronavirus pandemic. Things have moved so fast, from the virus first being detected in Wuhan, China in December, to all of our schools in Louisiana shut down in mid-March, to now when Louisiana, like most of the rest of the country, is under a shelter-in-place order, with no immediate end in sight. This is a scary time, and truly a time unlike anything else that any of us can remember. So that's why we wanted to produce this special program to address some of the questions that so many of you have about what happens next. So what happens if you get sick? How can you get financial help? How can you help your friends and loved ones? And what's going to happen to your job or your business? I'm going to be speaking with some very smart people who are going to be joining us from their homes. Just like the rest of the media world, we are taking advantage of the great at-home technological resources everyone has to stay connected and bring this important discussion to you. And at the same time, make sure everyone stays safe and at home in this special edition. Across 3 separate segments, we will speak with a workers' compensation attorney to discuss your rights regarding employment matters related to the pandemic, a CPA to help us understand what kind of financial benefits the government is offering individuals and businesses via the CARES Act and other programs. And finally, we'll discuss bankruptcy and other debt relief options that may be available or worth considering with that bankruptcy attorney. The COVID pandemic has dramatically affected our world, and this includes our court systems. As an attorney, I have received many questions from folks concerned about their ongoing cases and legal matters. So I thought it would be useful to answer a couple of the most asked questions right here before we move on. So on the screen, you see some of the questions that are most common and most popular. So the first question is, what is happening to ongoing civil and criminal proceedings? And what about jury trials? Well, the short answer is the courts are still permitting these cases to proceed. However, if you have hearings, if you have trial dates, all of those, unfortunately, have to wait because of the stay or shelter-in-place order. You just have to wait a little while, maybe a few weeks, probably a couple of months, because we can't have trials right now. Generally, the hearings have also been delayed, but courts are setting up to have hearings by telephone, by video teleconferencing, and so it's going to happen. These cases still continue, but be patient. Your cases still are alive and well. It's just going to take a little bit longer. Next question. Are we able to open new cases, file new lawsuits, and close old cases after they resolve? The short answer is yes. You can have new lawsuits. You can consult with attorneys if you've been in an accident or if you have a criminal case, if you have a traffic ticket you want to fight, and you can certainly close out your cases and settle them. Absolutely. It may take a little longer because of the reasons I just discussed. And the next question, what is happening with any case which I filed before the pandemic began? Well, same sort of situation. Your case still continues, your rights still are there. Unfortunately, a lot of courts, including cases in the courts of appeal, you just have to wait a little while. It's moving forward. You might have to have your hearing by telephone. Your lawyer can have the hearing with the other lawyer present on the phone with the judge. Even in the court of appeal, you just have to wait a little while, but it is going to move forward. So just bear with the courts, bear with the other side. It'll get moving. Next question. Am I going to be pressured to change a settlement or arrangement because of the pandemic? Well, the main thing that's going to be affecting your case is the delays. My advice to anyone who has a case is you shouldn't take less money simply because of the pandemic. You shouldn't offer more money if you're the defendant. You should simply do what your advice, take the advice of your trusted lawyer and do what is best for your case. Please find us on the internet resources seen on the screen. We will be right back with attorney Charles E. Wolf. Welcome back to the show. With the whole world standing still and people losing their jobs and livelihoods left and right, we knew it would be important to discuss workers' compensation and the unemployment climate. Here to give us the insight we need is attorney Charles E. Wolf. Charles E. is a local attorney who specializes in workers' compensation. Charles E., welcome to the show.
Thank you, John.
All right, we have a few questions, so let's get right to it. One of the questions from one of our viewers says, am I eligible for workers' compensation if I contracted COVID in the course of my work?
Well, that's an interesting question, and we are in uncharted territories now, as we all know. It really depends upon whether this person is a frontline worker, because just anyone can contract this airborne illness, but frontline workers, nurses, doctors, hospital staff, cleaning, EMTs, grocery store clerks are all basically considered frontline workers at this point. So possibly you would be entitled to benefits. There's nothing specific in the law right now. Everything depends upon the facts and circumstances surrounding the job, the employer. What actually did you contract? Did you contract the virus with no symptoms? Do you have any sequela, or what are the damages? So it's a very complex system. It could be an occupational injury, or it could simply fall under the definition of an accident under the workers' compensation system.
Right, so let me, just to be sure that we are explaining it more broadly for those people who have not had to go into the workers' compensation world and pursue a claim. Just because you get infected doesn't mean that you have a work comp claim. If you got exposed to the virus but you didn't actually get sick and you're able to keep working, let's say, you may not have a claim at all. To be eligible for a workers' compensation claim, you have to be rendered unable to work for some period of time. If you're made sick because of a condition on the job, then the employer may have to pay for your medical treatment. And if it's as a result of the job, and proving that you got sick from the virus, you mentioned people who are working in an environment where we know the COVID virus is, and it's more easy to prove it in that case. So if I'm understanding what you're saying, you're talking about people who can prove, if they were infected with the virus, that they got sick from being in a job that is more likely than not the virus happened on the job, as opposed to from a family member who got sick, let's say, and that it affected their ability to work, and it required them to miss work for some period of time. Is that a fair restatement of what you said?
It's fair, except to the extent you can still have a workers' compensation claim without missing employment. For example, it could be a medical-only claim.
Okay.
And we don't know the ramifications of what this disease is bringing to us. We don't know if it's simply a one-time exposure and you're fine after that. We don't know about any neurological problems that could be developed. Their brain injury, loss of taste and smell. Some people are having strokes. We really don't know at this point.
Okay. All right.
Fact intensive.
Right, and I don't mean to belabor the point, but you're right. And some people, they get infected and the boss sends them home, even if they feel pretty good. The boss has to worry about other people getting infected, and so they may not be able to come to work because of the infection. So, but let's move on to the next question, shall we? Can an employer fire an employee if the employer believes that the employee has contracted the virus?
I think that would be a very unwise move for any employer at this point in time. I think the ramifications from the OWC and the DOL will be great. Okay?
OWC and DOL, tell people what that means.
Department of Labor, I'm sorry. Both on the federal and the state level. There are protections in place. There's the Family First Act, which specifically delineates which employers are allowed to take what action, and everything is geared towards protecting the families and protecting the employers. To really answer that question, again, I'm not trying to waffle, but everything is fact intensive in workers' comp, even more so now because of the federal regulations. But the Family First Act protects employees, and it depends upon which category that employer falls into.
Okay. Next question. Can an independent contractor file a workers' comp claim if they contract the virus, the COVID virus?
Again, it depends on the definition of an independent contractor. We fought this for years. A lot of employers want to call their employees independent contractors. And as you know, there are certain things that distinguish an independent contractor. So simply, if it is a true independent 1099 independent contractor who receives that 1099 form, and they're responsible for all of their cost, and they basically do the job and are free and are not under the direction and control of the employer, then no, they have to file their own claim. If they have, which they should, workers' compensation insurance, then yes, of course they can file a claim.
So if you are an independent contractor and you have to pay yourself out of the money that you bill others, you should have your own workers' compensation insurance. That's your own safety net. And if you don't have your own workers' comp insurance and you are an independent contractor, you may be in a tough spot in this situation.
That is true. And by law, you do have to have workers' comp.
Okay. Next question. I believe my employer put me in harm's way by exposing me to the coronavirus. Can I sue the employer? Now, this is one you and I both could probably weigh in on, but I want to hear your response to that.
Well, there has been a lawsuit filed by a Walmart worker who contracted the virus and died. His family filed that lawsuit. I think that it really, again, depends upon the facts and circumstances. But just to give you an example, if there is an employer who knows that someone has coronavirus and insists that that person come to work, for example, or insists that the other employees come to work, then yes, I think you're going to be looking at what we call personal injury or tort suits in Louisiana. I don't think there's going to be any way around that. It's an intentional tort to put your employees in harm's way, especially in light of the shutdown and the regulations that John Bel Edwards has in place, Governor Edwards. So I think employers need to be really careful. There's going to be a lot of ramifications for the frontline workers, again, who are wearing garbage bags, who don't have the personal protective equipment. Even just going back to somebody who mops the floors in a hospital, they need to be protected. Yeah. It's an airborne virus.
Yeah, and you bring up a couple of really good points, and just because as a personal injury attorney and my firm is, we're affected in a lot of ways because thank goodness there are fewer cars on the road. That means there's less accidents. But for those heroes who go into work willingly, knowing there's going to be a lot of sick patients likely infected with the virus, and they put their own lives at risk, knowing that they have children who will be impacted, devastated if the nurses, the doctors, even those janitorial staff who go into those hospitals and have to clean up and disinfect. But I believe too that if you have to work in a place where lots of the public is entering, even if it's a grocery store, and you believe that infected people are in there, and you get sick, you may well have not only a workers' comp claim if you get sick and you can't work, or if you get sick, you may have a personal injury claim or a tort suit, like you said. And God forbid you find yourself in that tough situation. My recommendation is you should consult with an attorney, such as Ms. Wolf, or someone who does what I do, personal injury. So next question. My employer required me to, I think we asked that question. My employer, I think let's go to the next question. What if a family member contracted the virus in the course of work and died as a result? I think we kind of covered that, but any comment on that real quick, Charlesley?
If the family member is a dependent of the person who is deceased from COVID, yes, there is certainly a claim. It really just, again, it depends upon whether the person who is deceased is married or has children, and if the answer to that is no, and they don't have any dependents, then any funds from that death would go to the parents. But yes, they definitely can have a claim.
Okay, and I would just add to that, sometimes there is a personal injury claim, and same thing, if that person has any living relations, then a claim can be brought by blood relations, and if there was negligence that exposed that person to that virus, somebody needlessly was exposed to that dangerous virus, there may be a claim for personal injury. So next question. How does somebody file for unemployment if they have been laid off or fired because of the virus, and how long does it take to get unemployment benefits? Charles, not exactly your area, but you may have some help you can provide in responding to that question.
Well, I think that if somebody has been fired, they definitely need to apply for unemployment. There's two types of unemployment now currently. You can file, if you're fired, you can file for unemployment. You can also file for the pandemic unemployment for those who may not have been, they could be an independent contractor, somebody who is a true independent contractor, or somebody who's a freelancer, for example, and they could get benefits because these are unusual times and it's a lot easier. Governor Edwards has now reduced the waiting period. There's no requirement to file for a job every week. And so yes, those benefits are available.
Excellent. And on that note, we do have a CPA, a financial advisor, who's going to be joining us in the next segment to talk in more detail about the different types of financial support that come from the CARES Act and other financial means. But moving on to the next question. What about those who were fired? I think let's move on to the next question if I could. Can gig workers or independent contractors file for unemployment if they wouldn't have been fired or laid off other than because of the pandemic, but merely lost access to clients? Can you answer that question?
Yes, they can, and I believe that they can and they should. If they don't qualify for regular unemployment benefits, again, the pandemic benefits are comparable, and they can obtain those benefits. And how soon they're coming out, the state has hired additional workers. I know they're working on that. They've transferred some of the staff to now handle those excess unemployment claims. So they definitely need to file and file as soon as possible.
Okay. And it looks like we have time for one more question. My employer is not considered an essential service, so they should be closed, but they are defying the state's order and remaining open and say I should have to come into work. What should I do? Asked this person.
Again, it depends upon the type of employment. There's not one answer for every single thing. Okay. The law is a little gray in some areas, and this is one. It depends on who the employer is. Is it an employer who employs more than 500 people? Is it less than 500 people, but more than 50 people or 25 people? That depends. You know, in this case, I think that the Family First Act provides protection. We have an enhancement now to FMLA, Family Medical Leave Act, so that people who are afraid, and frankly, we're under a shelter-in-place act in Louisiana, at least in certain parishes. You know, we're not yet open. So I don't believe that a worker who falls under any of the categories illuminated under this revised Corona Family Medical Leave Act would have to go to work. And I think that, again, depending upon the employer, their job would be protected. And I don't think people, obviously the employer is in dangerous territory if they're opening up their employees to being, you know, contracting COVID-19. It really just depends upon what their job is. But they have protections in place. The federal government, Department of Labor, has put in place protections for those workers so that they don't have to go to their job. They can care for their family member. One of the exemptions so far is for parents whose children have young children who are not in school. The nurseries are closed, the schools are closed. Families first, right? So no, they don't have to go to work.
Okay. Thank you very much for that explanation. But that's all the time we have. Thank you so much, Charles E. Coming up next, we're going to have our CPA, Tom South, who will help us understand all the help the government is providing to individuals and businesses affected by the pandemic. We'll be back right after this. Welcome back to John Redmann, Power of Attorney. We're talking about how to better understand your financial strategies with COVID-19 and the shutdown of the economy. I'm pleased to have certified public accountant Tom South join us. Tom has been on the show before to talk about financial matters for individuals and businesses, and he is one of the top recommended experts out there. Tom, welcome back to the show.
Good afternoon, John. Thank you for having me.
I'm glad you're here. So let's get right to it. Let's start with you telling us what is this CARES Act and what help does it offer individuals and businesses?
Well, the CARES Act is all-encompassing. The CARES Act stands for the Corona Aid, Relief, and Economic Security Act. And it encompasses many different things with regards to the relief for businesses that are really hit hard by this pandemic. I'm going to cover, in general terms, the provisions of the Act. You know, as everyone knows, the first big provision is the Payroll Protection Plan. The next provision is the Employee Retention Tax Credit. The third provision is the Economic Injury Disaster Loan. And then we have the Sick and Family Leave Act. And then we have the deferral of the employer share of the payroll taxes. And there are other provisions, but those are the main topics. And I'm going to go back and hit on each one of those specific topics. The Payroll Protection Act is probably, and it's referred to as PPP, but it's Payroll Protection Program. That is meant to give businesses relief during this pandemic and time of crisis, in that it's a mathematical calculation. You can take your 2019 payroll divided by 12 times 2.5%, and that will be the amount of the loan that you could possibly qualify for. And I use the term loan, it's actually a grant that could be forgivable depending on the mathematical calculations at the end of an 8-week period. The problem that we're having with that particular program right now is, I'm sure a lot of your viewers and you have seen this morning, and when we even started talking with the financial institutions, the money was going to run out quick. As of the news reports this morning, it appears the money has run out. But hopefully there will be a second phase of funding of $250 billion, which we will pick that up in the very near future.
So I don't mean to interrupt you. Go ahead and conclude.
No, you go ahead.
All right, so this CARE stimulus package is just, it's one of the major forms of financial relief. There are other loans you alluded to, the EIDL or Economic Injury Disaster Loan, that is related to the forms of relief you just discussed. And I know it can get confusing to a lot of people. And one of the blockbuster bits of news that's just coming out is people who are eligible to get loans from the government to help their businesses stay afloat. Apparently they just ran out of money, is what you're telling us, right?
Yes, correct.
Okay. So tell us, what do people who didn't get that loan yet, or they applied and they didn't get the money, they didn't get the word the money's on the way, what can they do?
We're advising our clients and the contacts that we have with the financial institutions, and the financial institutions are telling them exactly the same thing. Continue the application process. get the application in and in line for the next round of funding. Make sure all the documentations or documentation is put forth and ready to go when the next level of funding is available. And just remembering that the Payroll Protection Act is one, the Economic Injury Disaster Loan is another phase of the CARES Act, and that you can't get both of them. You can get one and the other.
All right, well, you bring up a couple of really good points. Number one, it sounds like the early bird got the worm. The people who applied immediately and promptly were at the front of the line, and they used up the first, couple of $100 million or whatever.
$349 billion.
Right. They burned through that money right away, and that's just a fraction of the businesses that were available. So your advice to your clients, a lot of people come to you to help them make sure the forms are filled out right so they can maximize the money they get and repay the least. Is that accurate?
Correct. At the end of an 8-week period, we're going to run through a calculation to determine how you use the money, whether it was on payroll costs, rent, mortgage interest, or utilities.
Okay.
And then we can determine the forgiveness part of the payroll protection program grant that's given.
Okay.
And if there's a part that has to be rolled into a loan, it's going to be a payback of 2 years at 1% or 0.98%.
Okay.
Where the Economic Injury Disaster Loan is a 30-year amortizable loan at 3.75%.
All right. So I want to make sure that I'm keeping up with you, and hopefully others are keeping up with you. If you didn't get any of that first big pot of money, you should be applying right now, so you're at the front of the line or as close to the front of the line as you can be for the next pot of money, which we hope the government is going to create, so you can be close to that front of the line. Hopefully you'll get money the next go round, correct?
Correct. That's a true statement, yes.
Okay.
We're advising our clients to get the application in, get it signed, and have it in the bank's hands, remembering that the payroll protection program is handled by the lending institutions that do business with the federal government, and the Economic Injury Disaster Loan is handled by the SBA specifically.
And you mentioned one other important thing. You mentioned several things, but another one that I caught is there's that loan application process, but then there's this Economic Injury Disaster Loan, the EIDL loan, which is a separate loan application, and you can't apply for both. You got to apply for one or the other, correct?
Correct. You cannot use the same cost in applying for the loans. You got to use either the cost for the payroll protection or the Economic Injury Disaster Loans. You cannot use the same cost.
Okay, and unfortunately we have limited time, but can you sum up briefly why you would apply for one or the other? Is that something you really have to look at people's finances to guide them on that?
That's one of the issues, and one of the points we stress to our clients and the individuals that have retained us. Specifically, we have to look at specifically what fits your needs. The Economic Injury Disaster Loan gives you an immediate injection of cash of $10,000, where it was until they changed the program. When they started running out of money, they limited it to $1,000 per employee. So, but the Economic Injury Disaster Loan helps with your fixed cost over a period of time. And again, it's just like making a loan from the SBA, where the payroll protection reimburses you immediately for your payroll costs, related rent, mortgage interest, and utilities. And that's the forgivable loan.
Okay, and that's a change that just happened in law literally in the last business day or two, where it was a minimum of $10,000, and now if you only have 2 employees, then it might be $2,000, or if you have 5 employees, it might be $5,000. But if you have 20 employees, you can count on getting at least $10,000, and that pot of money is still there. That pot of money is still there, right?
Correct.
Okay, and you mentioned having clients and people who consult with you, your CPA firm, to get guidance on how to fill out these forms. There is a fee that's charged, but it's limited, and it's drastically limited by the SBA, correct?
Correct. There is a limit on the fee, which is $2,500, and the maximum fee that you can charge on helping a client fill out the application and providing all the applicable documentation.
Okay. And that's one piece of useful information. We want to make sure everybody out there who pays attention to this hears this. There are others out there who may want to guide you to get, tell you how to get money and maximize your money. It doesn't matter if you're going after this loan, that loan, some other magic bullet to get you the money and cut the line or whatever they're promising you. They get at a max $2,500. It doesn't matter if you're applying for $20 million, and we've heard word of one or two businesses around here getting their $20 million where a lot of people got none, or $10,000. The max fee that can be charged is $2,500 no matter how much loan money is being gone after, correct?
Correct. That's from the SBA. You can have an arrangement with a client to charge the client directly, but I don't know of any CPA firm that's doing that specifically.
And otherwise, the arrangement is you get paid when the loan money comes in?
Yes, when the loan money is funded.
Okay. And all right, well, I think we've covered that. I want to ask you a different question because we have gotten questions from a lot of different viewers. One question asks, how will people who do not have checking accounts be able to access stimulus money if they apply and are awarded the money?
Oh, but based on the current guidelines, the direct deposit is the preferred method, of course, from the Internal Revenue Service to issue the money. But paper checks, based on the current readings, will be issued eventually. And that term eventually is unknown. They're looking at May, maybe, as far as issuing checks, it may be later than that. But individuals who do not file or have not filed a tax return in the past, they can log on to the Internal Revenue Service website and go to Get My Payment and update their deposit information if they do now have a checking account and get the funds deposited in the checking account. Right now, 80 million Americans have received the stimulus check. And there's about 128 or 30 million people that file tax returns, plus the individuals on Social Security. And as you know, the individuals on Social Security and other non-taxable income, they're also going to receive the stimulus check.
All right, thank you. The next question says, if I owe back taxes, is the IRS going to confiscate my stimulus money?
That's a great question. And when you look back at the history of the Internal Revenue Service and look at the answer that's in the CARES Act, the answer right now is no, they're not going to confiscate your stimulus package. This is one of the very, very few times in the history of any type of stimulus where the government has suspended most administrative requirements. The only issue that in the readings that I have is that if you owe back child support, you're not going to get the stimulus package. But if you owe student loans, past due student loans, or past due taxes, you are going to get the stimulus check, which I think is extremely great.
Wow, that's great. So next question, and you may have answered this to some extent, but let's see if we can answer it directly. How can business owners apply for loans from the SBA?
Well, one of the big issues here, there's two facets of the major components of the loan process. One is the payroll protection, which is done through the local lender, and the other facet is the economic entry disaster loan. That's done on the website of the SBA, and believe it or not, it is fairly user-friendly. The SBA works with the local lenders to provide the lenders with small business loans. The SBA does not lend money itself. It just works with lenders specifically. So you can log on to the site, file the economic entry disaster loan, or you can fill out the payroll protection program loan and submit it directly to your lending institution.
And so, and I've looked at these forms too, and I've done some, in my law firm, we've done some guidance of people applying for these loans as well. The forms are fairly straightforward. Is it sort of user-friendly or dummy-proof, or is there some risk that people are going to be have to do follow-up after they file the loans, or there's a risk that they won't get everything that they're entitled to if they try and do it without having the guidance of a financial advisor such as yourself?
From a user standpoint, it's fairly user-friendly. Where the problem comes in is supplying the documentation required to substantiate or move the loan process forward. that's where we're finding most of our clients are having problems, whether it's payroll tax returns, current payroll, or prior year tax returns, or gross revenue, or cost of sales. There's many component pieces of the loan application that need to be supplied both to the SBA and also with the payroll protection plan.
Okay.
For the SBA for the economic disaster injury loan,
Okay.
and also the PPP through your local lending institution. So it's a follow-up, and not only is the follow-up on the application, when we in the eight-week period with the payroll protection plan, we have to true up the cost and tell the individual lending institution and the SBA how did we use the money, whether it was for payroll, and there's a requirement that 75% of the money has to be used for payroll costs, and the other 25% can be used for utilities, rent, mortgage payments, et cetera. Okay. So at the end of the 8-week period, there's going to be another hurdle to cover where I believe every individual who applied is going to need some financial assistance.
Okay. I want to get to business interruption claims, but before that, just so we're clear, if you are unincorporated, you're a sole proprietorship. In other words, you haven't incorporated, but you run a business, and it's a business you run. You drive for Uber or whatever. You haven't incorporated. You can file a business. You can file for a business loan as well. Correct?
Correct. You can file the payroll protection and it's normal, just like a normal incorporated business. And that was a change of late with regards to who can apply. Okay. Individual partners in a single member LLC or a small LLC, a husband and wife can apply as part of that process. Uber drivers, subcontractors that are construction workers, et cetera, they can apply. But it's the same process that a business uses.
Okay, and very briefly, some people have what's called business interruption insurance. There's a debate going on in the news. Some people say your business interruption insurance will not pay for this. If you can make a business interruption claim, that would be separate and apart from making a request for loan through the CARES Act or through the EIDL loans. Is that your understanding as well?
Correct. That's my current understanding. That the business interruption insurance will replace the loss of net profits due to this pandemic specifically. We're advising our clients, number one, to review their insurance policies and seek legal counsel with regards to how their policies specifically read. I have not read or heard of anyone filing a business interruption claim as we speak today.
Okay. All right. Well, thank you very much, Tom South, CPA. Very, very instructive. We're all out of time for this segment, but coming up next, we'll be discussing bankruptcy, consumer advocacy with attorney Bill Charbonnier, and that'll be right after this break.
Have you heard about social distancing?
This is very serious. We have to stay home.
Not just to protect yourself, but to protect others.
You don't want to spread the coronavirus in your community.
Stay at least 6 feet away from other people. 2, arm's length.
Staying home helps lower the risk for everyone.
Protect your life, protect your loved ones, and protect the world.
Just because you're at home
doesn't mean that we can't be alone together.
Together.
Welcome back to John Redmann, Power of Attorney. Many folks have asked questions about dealing with the financial burden of not having income. With good reason. People are stressed about everything from keeping up with their rent to putting food on their table. For some, bankruptcy suddenly seems like an option. Our next guest, attorney Bill Charbonnier, has been a consumer advocate, assisting folks in this area for over 40 years. We are pleased to have him here with us to share his insights. Bill, thank you for being on the show.
John, thank you for inviting me.
Great. So let's get started. For business owners and for individuals, what is your primary message to those who are feeling the financial strain and accruing debt from this pandemic?
Well, the first thing they've got to do is use the money that they've got on the important things. When you're limited, and there's only enough money to go around, you don't want to go spend it on the stuff that doesn't need to be spent on. I think one of the things that people need to realize right away is if they have any kind of automatic draft on something unimportant, they've got to go and cancel that with the bank immediately, because otherwise the money's going to come out and you're not going to get it back. That's going to be any kind of a finance company loan or anything that's unessential. Get that auto draft stopped. Now, there's things that are essential, and we can go over that if you have any specific questions as to what should be paid and what shouldn't be.
Okay, and we want to get into that, and we have a bunch of questions lined up, and so we do want to get into that, but let me get to the specific questions I have following up on that. For example, what kind of debt obligations are paused right now because of the pandemic? Mortgage, rent payments, loans from lending institutions. What can you comment about that?
Well, none of the payments are paused, but enforcement action has been paused by the CARES Act and also by the governor's proclamation. Additionally, the courts, both the Orleans Parish Civil District Court and the Jefferson Parish 24th Judicial District Court, have shut down a lot of the procedures that they're doing. So even though the payments may be due, for example, there isn't going to be enforcement action on federally backed mortgages because the CARES Act prohibited that. There can be enforcement action, and unfortunately, we're seeing that there are still foreclosures that are being filed right now, because even though the courthouse is closed, the mortgage companies can file electronically. But when there is a foreclosure normally when there's no pandemic, when there's no state of emergency, it generally takes about 4 to 6 months from the time a foreclosure petition is filed to the time a house is sold. The sheriff doesn't come there and start throwing people's furniture and possessions out on the street. It takes time to do that, and there's usually time to follow up on options such as Chapter 13s or sometimes even a Chapter 7 bank.
Okay. All right, well, thank you for that. But just in general, and we were talking about this before we filmed today, just the whole question of what do you do if you have very little income or very little money that's coming in and you have all these financial concerns? There's a bit of an analysis that you were recommending for individuals and business owners. What should they do with making determinations about what to do with their bills and making a determination? Could you comment on that, please?
Sure. The two things that are most important, the most important things to pay, number one is rent. Now, for people who aren't buying a house or don't own a house, for people who have to pay rent, whether it's a business or whether it's a home, if that rent isn't paid, there's going to be an eviction coming around. It's been stayed right now. The courts aren't handling evictions locally right now, but it's going to happen. And what the pandemic is doing is just, it may be putting a slight brake on everything. It's not forgiving it. There's no rent forgiveness. The same for automobile payments. Automobile payments are vehicle payments. If a business has vehicles that it needs and is paying on them, if it doesn't make those payments, these vehicles can be repossessed. And that has not, although no one's doing it right now, sooner or later you got to pay the piper on. So rent and car payments are two of the things that should be paid. When there's limited funds, that's what should be paid. Now, a house note, sure, you're going to have to pay that, but it takes time to foreclose, and people generally have a little bit more leeway.
What about credit card bills? What about other bills you get in the mail, from everything from your credit cards to money you owe on anything that's not your house note?
Well, those should be low priority, because when it comes down to survival mode, you're going to need a roof over your head, and you're going to have a means of transportation to get to the doctor, the grocery, and to work. As far as the credit cards are concerned, the credit cards are the easiest thing to take care of down the line. There's a lot of smoke and mirrors that the credit card people put out, and true, that it can be damage to the credit rating. But the bottom line is credit card payments, local finance company payments where there's no collateral. Things like that should be pretty much at the bottom of the line as far as payment.
Okay, okay. Next question has to do with bankruptcy. The viewer asked, if I wouldn't have considered filing for bankruptcy if not for the pandemic, should I wait it out and try getting help from the government instead?
It's probably not the best time to file bankruptcy until we find out what's going to be happening. We don't know when the economy is going to reopen. Even if the rest of the country opens up, the mayor of New Orleans has extended the time. So I think it's probably best to see what exactly is going to happen and to take advantage of any government programs that come about. It is an election year, and my hunch is that neither the Democrats nor the Republicans are going to want to see a lot of bankruptcies if they can avoid it.
Okay. Next question is, will individuals and businesses be allowed to file for bankruptcy if they decide they need to, maybe after consulting with someone like you, during the COVID quarantine? Aren't the courthouses closed?
The courthouses are closed, but the courts are not. We have electronic filing now. I mean, look at what we're doing. We're having this meeting electronically. And attorneys can file cases without ever setting foot inside the courtroom. So foreclosures can be filed, repossessions can be filed. They're not accepting evictions at this minute, but they'll be coming. But the quick answer, the sweet and easy answer is yes, people can file during the COVID crisis, but it might be better to wait.
Okay. And on that topic, just in general, and this applies probably in times of a pandemic, but also just in general, what are some of the pros and some of the cons of declaring or filing for bankruptcy?
Well, bankruptcy gets rid of your debts. It hurts your credit in the short run. Usually 2 years is the magic number. If you file bankruptcy and keep everything paid on time, for 2 years, you'll qualify for an FHA loan, a house loan, if you pay all your bills on time following bankruptcy. And of course, there's other qualifications. Bankruptcy eliminates debt, and by eliminating debt, it can sometimes help your credit rating a little bit, because credit rating in part is based on your total overall debt. If you have $50,000 worth of debt and then file bankruptcy and get it discharged, you have zero debt. And in some cases, that improves your credit in the short term.
And you mentioned getting rid of your debt, but my understanding from talking about this with you is there's also there's a Chapter 7 bankruptcy, which is common, also something called Chapter 13 bankruptcy. Can you describe what those are and what the differences between those two are?
Sure. Chapter 7 is when you're looking for a fresh start. You want to get out from under your debt, and you're not going to try to pay it. Not everybody qualifies for a Chapter 7. You have to be either below the median income for the state, or you have to pass what's called a means test. Chapter 13, on the contrary, is a debt reorganization. The bankruptcy court will give you 5 years to get caught up on your house note, as long as you start making the regular monthly payments. And you can redo an automobile loan, especially if the loan is more than 2.5 years. If an automobile loan is more than 2.5 years old, you can reduce the balance of the payable balance of the loan to the actual retail value of the vehicle. And that's a big deal for people who have cars that have lost a lot of value. So with Chapter 13, you make payments for either 3 to 5 years based on your income. And it's for people who have temporarily fallen on bad times, and they're getting back in better times.
Okay. Here's a question that we've heard some talk about. Can creditors, that is people, maybe they already have a judgment against you and they're trying to garnish your wages, can creditors take my stimulus check? And if so, is there anything I can do about that if I'm trying to get a stimulus check?
Well, they can take it right now because it is not exempt from seizure. There is a bill pending before the Louisiana legislature. It was introduced by Senator Pat Connick of Harvey that would make the stimulus payments exempt, not only for this, but also future payments for hurricane damages, natural disasters, national emergencies, but it's not exempt right now. The U.S. Trustee's Office has issued a guidance to the trustees directing them not to take it absent exceptional circumstances. But there's at least one of the local bankruptcy trustees who has already stated publicly that she will take the stimulus money under certain circumstances.
Okay. Another bankruptcy question. Does an individual get to keep his or her house if they declare bankruptcy? And if so, do they have to give up their house in the current climate? And there's not alternative housing available is the question.
They don't lose their house if two things are happening. Number one, they're current on all their payments. And number two, there's less than $35,000 of equity in the house. If we have what are called exemptions in Louisiana and every state, and that's what you keep when you file bankruptcy. If your house has less than $35,000 and if you are current on your house payments, you'll keep it. Now, if you're behind on your house payments, you may need to do a Chapter 13 and start the payments again. And people, that's one of the main reasons people do Chapter 13s. It's to either keep a house or to keep a vehicle. And under some circumstances, I mean, even with the situation we have right now, if someone was current or in foreclosure before the pandemic, then there's really no reason for them not to plan on filing the Chapter 13 if they want to keep their property. Because the longer you wait, the payments are still continuing to go up. If you get into a Chapter 13 now, your payment's going to be lower than if you wait another 4 or 5 or 6 months and you're another 4 or 5 or 6 months behind in house payment.
We're starting to run short on time. Unfortunately, we just only have so many minutes in a show. But what are some other ways of dealing with creditors short of filing bankruptcy or other than filing bankruptcy?
Well, before you file bankruptcy, you should always try to work something out with your creditors if possible. There's some creditors that really don't give a damn. We have, just today, we had some people who wanted to try, they were being sued before the pandemic, the shutdown. And we're trying to negotiate with the bank, but the bank just doesn't want to do it. I think a lot of that's going to change because the economy is going to change, and what banks would not take today, they might take in 6 months. We also don't know what's going to happen. I'm inclined to believe that with this being an election year, there's going to be some incentives that the government makes toward the banks to encourage them the banks and the credit card people. To try to encourage them to work things out. But the first thing you do is you try to contact the creditor. If the creditor gives you no alternative, then you may be forced into a bankruptcy or a Chapter 13 to keep your property.
And in order to pursue bankruptcy, they can get a consultation with someone like you and find out their options. Is that typically how people determine if bankruptcy is a wise move or not?
Sure. You really need to, you can go on the internet, but free advice is generally worth what you pay for. And that said, I will tell you that I think most bankruptcy attorneys do in fact give consumers a free consultation, but they don't do the bankruptcy, of course, for free, or else they'd be filing bankruptcy themselves. Almost all of the bankruptcy attorneys in the New Orleans area will give people a free consult for consumers. Now, for businesses, it's different. There's
a charge.
generally a charge.
Okay. Well, Bill, I'm so grateful to you for sharing your input and your insights into the consumer side of things. Thank you for joining us. This has been very helpful. Go to our website, johnredmannpoa.com, for more information. We'll be back after this short break.
Why should young people care about the spread of coronavirus? Well, we know that people with underlying medical conditions over the age of 60 are at highest risk, but they've got to get it from somebody.
So we're asking everyone to be selfless for others so that we can protect those who are most susceptible.
Not going to bars, not going to restaurants. It all just means physical separation so that you have a space between you and others.
For more information on how you can social distance, please go to coronavirus.gov.
Unfortunately, that's all the time we have left. Please visit my website, johnredmannpoa.com, to get more information about everything we discussed today. You'll find resources to help you understand and get through these challenging times. We are continuously updating this with the newest information as it becomes available. As always, you can follow the show on Facebook at John Redmann Power of Attorney to give us feedback and ask us questions. Please stay safe and stay positive. We will all get through this together. I'm John Redmann. Thanks so much for joining us on John Redmann Power of Attorney.